All right, welcome back. So next panel is a topic that has really been a staple of this conference since we started, which is managing the GDPR after a data breach. Really important and kind of an area that keeps developing. So let's start with our moderator, Jenny Arlington. She's counsel with Akin. She is based in London, and Jenny assists technology companies and other clients with compliance and in investigations involving cutting-edge data protection and privacy and cybersecurity issues. Welcome, Jenny. Welcome back.
Thank you. Thank you.
Also very pleased to welcome Cedric Burton. He's a partner of Wilson Sonsini. He's based in Brussels, and Cedric co-chairs the firm's global privacy and cybersecurity practice and is the managing partner of the firm's Brussels office. Welcome, Cedric.
Thank you, Ross.
Finally, I'm very pleased to welcome Patrick van Eecke, a partner at Cooley, also based in Brussels. Patrick is head of Cooley's European cyber data privacy practice and vice chair of its global practice. Patrick, great to see you again. Welcome.
Good to see you, Bruce.
Jenny, let me turn it over to you.
Sure. Thank you. Thank you, Bruce. It's a great pleasure to be here, and welcome to our audience and whoever is joining us right now. And fantastic to be discussing cyber incidents with Patrick and Cedric. So let me just set the scene. We have the latest available statistics from the ICO, which is the UK data protection regulator. So for the second quarter of 2023, the cyber incidents, which of course means a personal data breach where there has been a threat actor, malicious third party, have been on the increase by 157%. And these are just the reported incidents in comparison to last year, the same time. Then we have a huge increase in ransomware. The statistics are even more stunning there, where the largest percentage increase in the reported incidents has been in relation to malware, 550%, and in relation to ransomware, 241%. So against that background, I was wondering if our first question could be to Cedric and Patrick, what has been the most surprising development for you in the past 12 months? When you have managed breaches of the GDPR after a data breach?
Hey, Jenny. Yeah, okay, I'm gonna kick it off, and it might be surprising to you that to me the most surprising was not about ransomware or bad actors, because of course they're out there. But to me, what really struck me this year was that how many phone calls I got from clients who first proudly stated they moved to Teams or to Google Drive, and so all employees are actually uploading and collaborating on these collaboration platforms. And then a few weeks later, they called me, we've got a data breach, and it's not a bad actor. It's actually just it's our HR department that very enthusiastically started working on Teams. They put all the employee records and the bonuses on Teams, and they didn't realize that by default, that the Teams folder is open to the whole company. Is this a data breach or not? And then, of course, you end up in quite a complex kind of discussions about trusted recipients, notifiable or not, that kind of thing. So that to me actually was quite surprising, because it's not about bad actors. It's about identity and user access management.
Great point. Great point.
Yeah. So on my side, I think I've seen two things playing out this year. On the one hand, I've seen like very complex breach and a high level of sophistication into the breach that I've helped clients on. It can go from like traditional hacking to social engineering, insider threat, a lot of cyber attacks as well due to the geopolitical context. So that's one trend I've seen. The other one is the tendency of DPAs to get tougher and to really have higher expectation than 5 years ago or 3 years ago. Looking at transparency for very complete and thorough risk assessment. The speed in response to the breach is becoming really critical. And then there's a big focus on the organizational aspect of the companies as well. What was in place before, what the company is looking at to remediate the potential issue. And I do think there is a big tendency in Europe right now to fine companies as soon as they report a breach, which is kind of a counterproductive effect, I think. But as soon as you notify under 33, you nearly always get follow-up questions and investigation. And if you look at some stats, in France last year, 60% of the fines included the violation of Article 32. which isn't breach but security. So it's really a hot issue right now, and frankly, I think it's a low-hanging fruit for regulators in the EU at this stage.
Yeah, absolutely. I couldn't agree more. Well, let's just dive straight into the breach then. Say you've suffered a cyber breach, the organization has understood that it has suffered a data breach. What are the practical tips that we can share with our audience in terms of the immediate aftermath? Whether what teams internally do we assemble? Do we go straight to external assistance? How best to find the data that has been compromised? Patrick, you're on my left, so shall we start with you?
Yeah, sure, Jenny. Well, let me maybe start with what should not happen, but in practice, this happens very often. And I very often see, actually, I'm confronted with two types of scenarios. One is that you get a call as outside counsel, and actually the data breach already happened quite some time ago, and it was only dealt with by the IT team or by the information security experts. They believed they were able to solve it themselves. Then it got escalated. Then the legal department gets involved, and then it's only then, actually, could be several days, several weeks, several months later, that actually you get involved. And then you see that from a very kind of small thing, at least initially it was thought like, no, we shouldn't exaggerate it. It's just a small thing. It starts to explode. That's one thing that I see. On the other end, what I also quite often see is that the company is really panicking and is starting actually to shoot each other internally, and so that the IT people or the information security people, they start coming up with emails. I knew this was going to happen because I already mentioned last year that we have not invested enough in information security. What Cedric just mentioned, the Article 32 kind of requirements, or that someone in IT is saying, I'm so sorry, I know I messed it up completely. And so what you're seeing is that a lot of bad documents are being created. Some things that you as a lawyer, as outside counsel, thinking already about the next step, about liability, you do not want to see that kind of internal documents that then afterwards could come out in kind of discovery procedures, that kind of things. So, Jenny, in an ideal situation, actually, the moment that a data breach is discovered, we can discuss what means discovery or not of a data breach, but the moment that you actually are alerted about a data breach, your IRP, your incident response plan, should be triggered. Your incident response team should be activated. The outside counsel should immediately be called. Outside forensics should get involved, and your cyber insurance should be called. And in which kind of priority or order of priority? Well, chronologically, this all should happen within the next 20 minutes after you know about the data breach. And why would you need, for example, outside forensics? Well, to get that kind of neutral, independent view, because all too often you notice, and of course we're all human beings, something has gone wrong. That's quite clear. And so quite often you notice that within the company, someone is trying to downplay the things and say, it's not, we're going to solve it ourselves. Don't worry. I'm the only one who knows how the system works, etc., etc. So it's good to have outside independent forensics as soon as possible going into that. These actually are my initial thoughts about what do you need to do within the very first 15 minutes.
Yeah, absolutely. And I agree. I mean, tabletop exercises are so useful there to kind of know what you're doing so that you've had a dry run and then you don't scramble later. Cedric, did you have any other thoughts in that respect?
No, I mean, I generally agree with what Patrick said. I think it depends on the breach. It depends on the company. I think there is no one size fit all approach to a breach. But, generally speaking, I think, be quick, bring everyone together. Follow the incident response plan, have an incident response plan in the first place. There are still companies who don't have a good one. And then test the incident response plans to make sure that you know what to do when there is an issue. I think once you're bringing everyone together, I think it's critical to try to contain and prioritize, contain the breach. and then assess, relatively quickly, because you will need to know, the type of data, the context, the location of individuals. That's the three key issues that are needed at the beginning to make a legal assessment. But you definitely need to bring the people in. On the role of the outside counsel, I do think it depends on the company. If you deal with a large multinational company, they're going to have a crisis management team, which is usually pretty sophisticated, and it's going to coordinate the matter and handle it, and then you're going to be plugged on that. If it's a smaller client, you might play a more active role and play the coordination role as well. So it really depends on the breach and the client you're dealing with. But otherwise, fully agree with everything else.
Yeah. And that containment point you mentioned, I mean, it's just so important, isn't it? Because we have seen fines and large fines in the millions here, where the companies have actually tackled the breach to the extent they thought they could do something, but they haven't really been prudent. And it turned out 3 months later, 6 months later, that actually the attack is still in their system. And that's where the regulators are really zooming in, saying, actually, you couldn't have tackled it properly, could you?
Yeah, and I think you have tension there definitely between you need to operate the business, because that may mean containing, may mean, putting some servers offline and not being able to conduct business as usual. And so there is a huge tension between, keep going on the one hand and then contain the breach on the other hand. You also need to know where the breach is coming from, because sometimes that's the information you don't get immediately. But I think contain the breach is really the first thing you should try to do.
Yeah. And then we talked about timing. I think I think with the GDPR 5.5 years under our belt now, we all know the 72-hour limit. Have we seen any developments recently, whether regulators have taken this more seriously? I mean, the statistics from the UK is that 57% of breaches are reported within that deadline. So it's obviously not exactly in the middle, but quite a big split in terms of what gets reported within the deadline and not. What are your thoughts on that, Patrick?
Yeah, well, we have it in the GDPR. It's written in black and white, 72 hours. Within that time limit, you need to report. Noticing in practice, actually, it's not such a big deal, I would say. And then I'm talking about whether it's 80 hours or whether it's 3, 4 days, 5 days, 6 days that you need. That I haven't seen any data protection authority that was really very aggressively enforcing the 72 hours kind of limitation period from that perspective. However, what I do see is that companies have been sanctioned throughout the European Union. So you mentioned United Kingdom, not the EU, of course, but also UK GDPR, similar kind of rules. But throughout the European Union, you see Poland, Spain, Italy, France, Germany, throughout the EU, companies are being sanctioned for not respecting the deadline, not by a few hours, but by many days, many weeks. And that is something, or just not reporting at all. And that is quite important to see. So I just, again, I checked a few kind of cases that came in earlier. And so that where companies have been sanctioned. And so one of the most recent ones actually that has been made public is about, in France. It just happened about a few weeks ago, Canal Plus, which it's a paid subscription kind of Netflix avant la lettre. And so they actually, these things can happen for about 5 hours only. For about 5 hours, the subscription details of about 10,000 customers was actually, it was not out there on the web, but people actually, other customers were during that period of 5 hours, they were able to get access to actually the subscription data of Gianni or Cedric. And so this was a kind of data breach following the CNIL, the French Data Protection Authority, but not following Canal Plus. So they've done their own assessment. And as you know, when it's risk, when there is a risk, you need to notify. High risk, you need to notify the individuals. And they believed, based on their own assessment, that this actually was not due, there was no duty to report. Well, the French Data Protection Authority, they actually did not agree. And they said, you should have reported. And of course, you were too late because you didn't report. So a fine of 600,000 euro, around 650,000 US dollars. So that's not a small fine any longer. So yes, you do see nowadays data protection authorities, they're looking into to what extent companies are taking it seriously. It's not about the 72 hours, but for sure without undue delay, if you could say so.
Yeah. It's the hours, the days, the years. Yes. Cedric, sorry.
Yeah, I agree to that. I think, in most countries, you do have like the ability to notify in phases, actually. So, you can stop the clock, say we had an incident, we're looking into it, and then file a follow-up report. So in practice, it's, once you're involved at the early stage, and it's 72 hours from becoming aware of a breach, which is open to interpretation as well. When do you actually become aware of a person with that breach? But otherwise, yeah, I mean, DPAs are not looking at, okay, you filed 73 hours after becoming aware of the breach. They are looking at the big picture and see whether you've been proactive, diligent, and have, done your best to comply with the GDPR and its obligation.
And that's something, Jenny, just to continue on that, something we see quite often in practice is that this kind of assessment, whether or not to notify, it's quite often done during a kind of a Zoom meeting or a Teams meeting, and it's not enough. When you come to the conclusion that you should not report, you need to document it. There is that legal obligation that you gotta have it on paper, the assumptions and the assessment you did, so that afterwards, when you're actually going to be questioned and challenged on why you did not notify, that you can say, well, we've done our homework. We know actually, we've taken into account these different criteria, and this is actually our honest, independent, because we work with third parties, outside counsel, etc. And this is the conclusion we came to, because it is not a mathematical calculation. We do know that, for example, ENISA, the cybersecurity agency, they do have their kind of methodology that we would highly recommend to apply, but still, it is not a kind of, again, a mathematical binary kind of calculation to be done.
Yes, absolutely. And we have, so the data breach log, I think it's a highly useful document, even to show, your regulators, but any other businesses that might want to look into your business for whatever reason, just to have something. And of course, we can discuss a little bit later how to record things in a, I would say, objective manner, so that you're not exposing your weaknesses, as we were just touching upon a little bit earlier. We do have an audience question, and actually a couple which I think makes sense to ask now. So there is one question in relation to CNIL. Thank you very much. Does the CNIL case suggest that the assessments of the duty to report should be more conservative? And what is news about cases that need to be reported or not to be reported? And then let me just ask the other one, because they're connected, in terms of the threshold. What is the threshold for activating the incident response plan, and how severe should the data breach be before a company contacts outside counsel? Would you like to share your views on that?
Yeah, on the reporting threshold, I think one point which I find interesting is the fact that if you look at the EU, a lot more breach are reported in the north of the EU, in the UK, in Ireland, Netherlands, and countries south of Europe, there are a lot less breach. I think there is a reason for that, is that regulators in the south of Europe tend to investigate the breach which are reported a lot more. So they are disincentivizing companies to notify. And, in nearly all cases, you do get follow-up questions. While if you look at the north of Europe, the UK or Netherlands, there are a lot more breach notified, but the regulators tend to focus on the big breach and not on every single breach. So, the threshold in the law is relatively clear. But, it's interesting to see that companies adjust to the behavior of the regulators and how they tackle that. On the incident response plan, I think, the bottom line is when there is a security incident, we trigger an incident response plan, and part of the plan is to assess whether it's a breach or not. And if it's not a notifiable data breach, personal data breach, then fine, you log that in. and then you take it from there. But like, I think it's important to, the entry point of the incident response plan is not a personal data breach. It's an security incident, which may or may not involve personal data.
Yeah, I fully agree with that. So it all starts with an incident, and some incidents are or will be qualified a data breach in the sense of the GDPR. And it's only when it's considered a data breach as defined by the GDPR that actually Article 33 is being triggered, which has that kind of documentation obligation. The problem now is that a data breach is being defined by the GDPR in such a kind of broad sense that I would say just as soon as you've got an incident and it is relating to a security incident and it relates to personal data, and we know that the definition of personal data in Europe is extremely broad, you end up in that situation. This incident is indeed a data breach. And it could be a very small data breach. It doesn't matter. You need to go through the exercise of assessing the risk, normal risk, high risk. And that, of course, that very often, typically when we as European lawyers, both Cedric and I, when we are having this kind of conversations, typically with US-based clients, very often these are the topics of discussion that it starts already with what is personal data, what is a data breach under European legislation, which might be different in other jurisdictions indeed.
Yeah, absolutely. I mean, personal data in Europe is so pervasive, isn't it? It's just in the vast majority of incidents, you would touch on personal data under the GDPR. I would say it's almost inevitable, or you have to have a really solid reason and explanation in the data log, as you said, as to why you don't think there is any. But we touched on notifications and that tension with the US, or I wouldn't say tension necessarily with the US, but regularly, I think our clients are just faced with multiple jurisdictions. It's so very rarely a data breach just in Spain or just in Luxembourg, and they have obligations that they need to comply with against various regulators, not only the data protection authorities, but that kind of tension between what the GDPR requires in terms of the regulatory notifications and what other jurisdictions may actually require for companies to report to the individuals affected by the breach. And we kind of time and time again face this question of what we would like to tell customers or individuals affected and what not to tell the regulator. And there are certain regulators in other jurisdictions outside Europe who would volunteer information reported to them. That becomes quite tricky. Do you have any practical advice for audience?
Yeah, so I think that's a really good point, and there's definitely tension out there between different jurisdictions. So, you have the patchwork of legislation in the US, you have the EU, and then you have like Asia Pacific, which has a bunch of notification requirements. South Korea is really, really very easily triggered. And so there's a tension between all of that. I think in practice, the lowest threshold is going to lead what the company will do. So let's assume you're dealing with like a global data breach, which implies 65 countries and millions of data elements. Give you a concrete example. If you trigger the notification obligation in a state in the US, and some states have low requirement as well, you're going to make public notification to individuals, which means that the press is going to be aware of that, which means that practically speaking, there is no way you're not going to notify regulators of it because you want to anticipate the fact that they might learn about it, whether or not you feel strongly that the threshold is met or not. From a practical standpoint, you want to anticipate that. So, the lowest threshold is going to lead into notifying regulators. I think another factor which plays a critical role in what you do is like whether it's public or not. As soon as it's in the press, from a business standpoint, you want to reassure consumer and customer that the breach is under control, that you have taken steps, remediation, let them know what they need to do. And that's putting aside the law, what the law requires. The law roughly requires the same thing, but, you want to do that. But as soon as you make public communication, they definitely need to notify the regulators. So I think the tension is out there, but in practice, you're going to follow the lowest threshold, and that's going to be the driver for the rest.
I just wanted to add that this is very often a conversation that we are having with US clients, where under the US legislation, well, under the European legislation, the lowest threshold, so if it's just a risk, you need to notify the regulatory authorities. And it's only if it's a high risk that you need to reach out to the individual victims, to the data subjects. Now, in the United States, it's very often the other way around, where companies say, well, we even voluntarily, we actually are going to reach out to our customers to tell them, but we're going to stay away from the regulator. We don't do that. We don't have, if we don't have to do it, we stay away. And then when you have the same data breach happening in Europe, because indeed, as you mentioned, Jen, it's so often cross-border, then actually we need to explain that, well, in Europe, maybe you don't even to notify the individual customers. Yeah, but we want to. Yeah, but you don't have to. But you're going to have to notify the supervisory authority. Oh, really? Is that true? We don't want to do that. And that's a very difficult discussion, because indeed, once you actually reached out to the data protection authorities, you actually kind of voluntarily already open yourself as a company to the supervisory authorities. And we've seen in the past that very often a notified data breach is actually leading to, you could call it a fishing expedition from the DPA, who then says, that's interesting. So they have a data breach. Let's go and dig a little bit deeper into that. Could you please inform us about your DPO? Oh, you don't have a DPO. That's interesting. Could you please then share with us your ROPA, your record of processing activities? Oh, you don't have it. So where are you based? And you don't have a representative. You're not based in Europe, but you don't have a representative. And then you notice it's a kind of avalanche of non-compliance action items that are being identified by the data protection authority. And so as a consequence, you see quite often that companies who actually notify the data breach, even if it was a minor data breach, they may end up in trouble, and there might be an enforcement action taken, not because of the data breach, but yes, maybe because they didn't take the necessary relevant security measures, and or they didn't appoint a DPO, or whatever you can imagine that they was not in compliance with the GDPR.
Yeah, very difficult. It can become very difficult very quickly for companies.
Yeah.
Let me ask something different. In terms of ransomware, I mentioned at the beginning, it's on the increase exponentially, I think, and we're facing this tricky question where a company is, subject to a ransomware attack, the first kind of single extortion level where you have your data encrypted, but you actually have been quite good and you have backup file and it's immediately available. And then you have the second extortion ransomware, where actually double the whammy, the ransomware, kind of the cyber criminal really is saying, well, great, you have your backup, but what I'm going to do, I've exfiltrated your data and I'm going to publish it openly, or either sell it on the dark web, so you better pay me. And then we have now, the next layer is the triple extortion ransomware, where they're using other tactics like denial of service attacks or going to your customers and suppliers. So it's becoming very difficult. And that tension with the regulator, who is certainly saying paying the ransom is not a good idea. It's not going to be looked at favorably. What can we tell our audience are the best practices for kind of preventing ransomware or dealing with it as and when it happens?
Well, I think at a high level, the dynamic is the same, meaning that you have an incident response plan which anticipates ransomware. I think the one pitfall that companies should avoid is to pay. Like usually when you pay, it doesn't solve the issue. It's just keep going. So, do not panic, do not pay, bring the right people in, IT forensic people, external consultant, negotiators, trigger incident response plan, make an informed decision about how to address it. I think it's really critical to stay calm. From a practical standpoint, having a good backup is kind of the first step, but it's striking to see that in most cases there is no good backup. So, there's actually like a potential for a huge loss of data, which has a huge impact on the business afterward. So, that's really something. Law enforcement is like another topic. Bring them in. I think there are very few instances where law enforcement should not be brought in that context. They have different tools, they have different, skill sets, different powers than the company and the best consultant in the world. So, bring them in. I think another point which I do see often in practice is another tension between the need to report to regulators and all individuals and the need to work on the ransomware. You don't necessarily want this to become public. Actually, most of the time you want to keep it under the radar and want to try to resolve the issue first, solve the IT issue, contain the breach, and then secondly, try to deal with the people behind the ransomware. If that becomes public, that's kind of game is over, the damage is done. There may be a way to cut the issue, but most of the time you really want to avoid that. So, that's kind of the 2-3 high level advice I would have. Maybe a fourth one is have a very clear process for ransomware in your incident response plan. Do a tabletop. They will always involve business discussion with the executive because it touches on the core of the business operation. So, that's something you want to test in advance, and then, make sure to comply with sanctions rules as well. There are most of these folks doing ransomware are on sanction list. So, there is a lot of protection on one hand, which has to be taken seriously. There are sanction lists on the other hand, which can be criminal as well. So, just something to keep in mind.
Yes, absolutely. And we have, Patrick, before I give the floor to you, we have a question from the audience on this point that maybe you might want to cover. And the request is, could we briefly cover what are the best ways of effective training to the employees not to be victims of ransomware or phishing? And of course, we have the spear phishing even worse as a prevention measure. Really important question, which I'm sure will be on the mind of a lot of our listeners.
Well, no doubt. To respond to that question, it's all about training, and we see in more and more companies that training efforts are really being undertaken, and that you already mentioned also tabletop exercises, but they could be quite broad in the sense that what I've seen with some of our clients being done, that actually phishing attacks are being done, but in a controlled and organized way. So to see actually what is happening. And so those employees who click through, etc., they actually said, oh, this actually was us. Make sure next time you don't do it again. And so it's all about it's about awareness creation. But still, if it happens, what I've seen, especially the past year now, and is with ransomware, with this kind of attacks, it has become business as usual, in the sense that these people, they're working 24/7 for sure, but what they actually do, it's just like going to their job and they have scarce resources, and so they're looking for the lowest hanging fruit, and so they are just sending out this kind of attacks, and so seeing what is coming in, and then they're trying to get a ransom, etc., etc. Now, what you see is that, or what we recommend is, bring in the negotiators immediately, the people who have done this before, who know how to deal with those people that are active on the dark side of the internet. Because you don't know. It's the first time, hopefully, you will ever be confronted, and you're confronted with actually these bad people. These people, these negotiators, they know the concepts, the terminology, etc. And what I've seen in quite a few cases, that actually by just having those negotiators going into conversations with the attackers, asking for confirmation. Are you really the one you believe? Are you really representing this kind of hackers collective, etc.? These people, they start focusing their attention on some weaker victims. And because they don't have time to do all this kind of drafting emails and responding, so they drop that matter. They just leave it. They don't even publish it on the web. Even that is already taking too much time for them. And so you can actually, by being confronted with ransomware, we would always recommend to bring in experts who have done these things before and are doing those things on a daily basis.
Yeah, no, great practical advice. I agree. And obviously there is the extra benefit there that the longer you can string as a business those type of negotiations, the more time you have to get your house in order, get those backup files, figure out what exactly has gone missing and already. And shall we touch very briefly on AI, because it wouldn't be a panel of this day and age unless we chat very briefly on AI. But I think, in fairness, what AI can achieve in cybersecurity, especially in terms of protection of against ransomware, it's huge. It's a good force. Well, it's a force for good. If you have the AI chatbots that can help you code. You have many measures that AI can help with, but on the other hand, it can be really quite a tool for the evil. So, and all eyes are on Brussels right now. We're waiting with eagerness to see if the AI is going to be passed.
It's a circus.
Yes, it is. It's a soap opera. I'm quite enjoying it. So is there anything that we can offer on the practical side for our audience on AI and cybersecurity?
Maybe just some immediate kind of comment is that, of course, AI is going to become a new tool for the hackers, for the bad actors. They are currently using it. And I'm just waiting for the very first cases where it's going to be used for social engineering. So now, of course, we got the kind of the mails from the CEO to the finance department, where this is what's happening now. Of course, it's a fake email from the CEO about transferring money. Well, we're going to see very soon AI-enabled or AI-created voices and phone calls being made from the CEO. Yes, you haven't responded to my email yet, that kind of things. It's for sure, that's going to be a reality very soon. What I see already happening now, though, is in the other way around. It is that companies more and more using AI internally, experimenting with AI. For example, Microsoft Copilots, actually, it's becoming a kind of risk in the sense that this hugely intelligent artificial intelligence is actually able to go through the computer system and find any kind of information that was hidden somewhere. A human being would never be able to find that information, but with using Copilot, for example, or Delph, you would be able to retrieve that information that was not probably supposed to be retrieved. And so there could be risks within companies for data breaches just by actually applying and playing around now, experimenting with artificial intelligence without realizing how impactful it can be.
I think AI gets both ways, really. It's a great tool to monitor what's going on the network. It's a great tool for attackers to build attacks and social engineer. And there are already a bunch of cases out there where voice system or AI's voice algorithm have been taking the voice of like politicians or like well-known folks. So there are a few cases out there right now. So it's already happening. So yeah, I think it's going to go both ways. It's a great tool to prevent. It's a great tool to attack. So I think you have to be on top of it right now if you want to have a pretty good defense system. You need to involve some AI in it.
Yeah, I agree. Right, shall we turn? We have another question from the audience. Thank you very much. And I think it probably ties neatly with another topic I was hoping we can discuss, which is in terms of the regulators and how regulators are approaching the fines, the penalties, the enforcement and investigations. Again, with so much time now, the GDPR being enforced, and I think it's a comment and a question from one of our audience member, and the question is: do we think the universe of data breach notifications is about to potentially change quite dramatically if the European regulators on the data protection side follow the securities and banking regulators, the SEC cyber rules, the dramatic heightened relevant corporate governance? What will be the knock-on effect on cyber insurance brokers, among others? Cedric, would you like to offer your view probably on that and the various regulatory actions?
Yeah, so a couple of thoughts on this. The first one is, I think generally speaking, regulators in the data protection regulators are not really experienced when it comes to security. So the general level of knowledge when it comes to IT at DPAs is relatively low. That's not what they do. They are not like engineers. Most of them have little experience dealing with that. There are some exceptions to that. You know, the ICO has like a strong IT team. The French DPA has a strong IT team. You have like engineers in the Netherlands. But like, if you look at the EU as such, you know, most DPAs don't have the resources to deal with that. Now, over the last 5 years, they've been acquiring skills, and so I think they are better equipped now to assess a breach. They've hired the right people as well. There is a clear trend to look at what other regulators are doing. So all the examples you gave are, you know, it's like kind of assessing what are the market practices and what's the state of the art. And so, you know, it's helpful for regulators and companies to have this standard out there so that you can benchmark against them. You know, I will not go as far as saying that the banking sector is going to be the state of the art, because the banking sector has its own rules, which are really specific to the financial sector. But definitely ENISA, you know, the SEC rules in the States, and all kind of like, certification, code of conduct, will be helpful when it comes to that. You know, I think you do have, and I made that point earlier, like a split in the EU among DPAs. Some are more conservative than others when it comes to data protection. I think something to keep in mind is, and Patrick made the point earlier, regulators don't know what's going on. You know, they learn about what's going on in the press, through complaint, and through breach notification. So that's the entry point for them to kind of look into what companies are doing. So I do think that the trend of having notification being the trigger for investigation, and sometimes opening fishing expedition, frankly, I would use that term as well, is going to continue. And I think it will be for company and lawyers to push back on that and tell them, well, there are rules under administrative law to comply, proportionality principle and the like. But yeah, I do see that trend continue.
Yeah, and I think in terms of regulatory enforcement, I'm certainly seeing a lot more interest on investigations and prodding and asking where there is a cyber element, by which, as I said at the beginning, like a malicious threat actor, not so really interested in inadvertent disclosures on the investigation side, recorded with no action to follow, or noted, maybe your company is under the kind of like microscope of the regulator, but certainly no, not as many investigations and penalties.
Yeah, and Julie, actually, I have a question. I think there's an interesting point. I'm curious to see what you think of this. Like, the ICO has been a pioneer when it comes to breach. You know, the first two big fines which have been out there pre-Brexit came from the ICO. I've not heard anything from the ICO on breach for a long time. You know, past these two big data breach, there's not much in the press now. Like, what's your take on that?
Well, so there is, I think, the ICO, I'm not sure it has changed tactics. It has certainly been extremely focused on bringing compliance for businesses, helping, attending very many kind of business events, conferences, putting up guidance. They have been extremely busy, and they have enlarged staff members and the staff numbers for sure, and hiring, including kind of data scientists and more technical experts. I think there has been more recently a £4.4 million fine for a cyber incident. As I mentioned earlier, a company that thought they had dealt with the threat actor, but actually they hadn't properly. I think we will probably see more. With the UK, as you would have seen in the press, is going on a different path from the EU with developing proposals for a new data protection bill. But I do think there is more focused on helping companies comply, or an increased focus on that.
Yep.
So I am conscious of the time. I very quickly wanted to cover, if we can, class actions, because I do know that there is another area of difference between what is happening in the UK on personal data breaches in Europe. Patrick, would you, the directive is obviously making its way through member states. You have a recent case.
Yeah, I think that actually, if you would be asking me what's your concern for 2024, that would be my concern. It is the combination of the one hand, our European class action suits legislation, the collective redress directive, which had to be transposed already 2 years ago, but the member states, they haven't. They all received letters from the Commission. We're going to get there. So once every member state of the EU is going to have its class action suits legislation in place, and that combined with another quite interesting new development at the European Court of Justice level, namely about getting compensation for immaterial damage based on the GDPR. You know, you're a victim of a data breach, someone actually got your email address. What's the damage? What's the material damage? Very difficult to kind of materialize. But you could say, well, I have some kind of discomfort, and to me that is 500, 5,000 worth in compensation. I don't know. That's going to be up to the judge. Well, the Austrian Post case, that's the case where the Court of Justice has decided it is possible for a data subject to actually get compensation for immaterial damage, how minimal it is. There is no minimum threshold. So put that together with the possibility of the class action or the collective redress directive, where you can actually engage in cross-border European class action suits, not just in France, but Germany, France, Italy. You can bring everybody together, all asking €5, 500 euro for compensation. That, I would say, is the perfect storm for companies in 2024, 2025 confronted with a data breach.
Yeah. Agreed. I see Bruce has come online, and I think that probably means our time is up. Is that right, Bruce? I think
it is. Cedric, did you have any comment you wanted to make on that point before we go?
No, I fully agree on the litigation point. Actually, there are already a bunch of class action litigation or quasi-class action litigation going on through like special vehicle entities in Germany. I've been really busy on that over the last 2 years. You know, the Netherlands as well. There are a bunch of class action against a number of big tech players there. So I think we're already there, but it's just the beginning of it, and we're going to see a lot more in the coming years. So, you know, we're bridging the gap, I think, in the wrong way between the US and the EU, but you're getting there.
Okay. Well, Jenny, great job moderating, and Cedric and Patrick, thank you so much for joining us from Brussels today, both of you. Our next panel is at 3:25 Greenwich Mean Time, and we will be back with a discussion with Dr. Andreas Mitrakis from the European Union Agency for Cybersecurity. So we'll see you back here in a little under 10 minutes. Thank you.
Thank you.